Is contributing to child abuse a crime that can land me in jail in Creek County? In Oklahoma, contributing to child abuse or permitting child abuse is a very serious criminal allegation that can absolutely result in jail or prison time. Prosecutors in Oklahoma aggressively pursue these cases, especially when they believe a parent, guardian, caretaker, or other adult knowingly allowed abuse to occur or failed to protect a child from harm. Because these allegations often involve both criminal court proceedings and DHS investigations, the consequences can become severe very quickly. Oklahoma treats child abuse-related crimes extremely seriously. Under Oklahoma law, prosecutors may file charges involving child abuse, child neglect, enabling child abuse, or permitting abuse depending on the circumstances of the case. These allegations commonly arise in situations involving domestic violence in the home, physical injuries to children, dangerous living conditions, drug activity around children, failure to seek medical treatment, and allegations that one adult knew another person was abusing the child. In many cases, prosecutors argue the accused had knowledge of the abuse or danger and failed to take reasonable action to protect the child. Jail or prison time is possible. Yes, incarceration is a very real possibility in these cases. Depending on the severity of the allegations, prior criminal history, and the injuries involved, prosecutors may pursue felony charges carrying substantial prison exposure. More serious allegations involving severe injury, repeated abuse, torture, or death of a child can expose a person to lengthy prison sentences in the Oklahoma Department of Corrections. Even in cases where the accused never physically harmed the child, prosecutors may still seek incarceration if they believe the person knowingly allowed abuse to continue or failed to intervene appropriately. These cases often involve parents or caretakers. Many contributing to child abuse or permitting abuse cases involve allegations against parents, step-parents, live-in partners, guardians, babysitters, and individuals responsible for supervising children. In some situations, one adult is accused of directly abusing the child while another adult is accused of allowing the abuse to occur or failing to report it. These cases often become emotionally charged and heavily investigated by both law enforcement and the Oklahoma Department of Human Services. DHS investigations frequently accompany criminal charges. Child abuse allegations often trigger simultaneous DHS investigations and juvenile court proceedings. A person accused of contributing to child abuse may also face emergency custody proceedings, juvenile deprived cases, loss of visitation rights, and termination of parental rights proceedings. Statements made during DHS interviews or investigations may later be used in criminal court. Because of this, individuals should be extremely careful before speaking with investigators without legal counsel. Prosecutors often rely on medical and expert evidence. These prosecutions frequently involve pediatric medical experts, DHS investigators, forensic interviewers, emergency room physicians, and law enforcement officers. The prosecution may attempt to use medical records, photographs, expert testimony, and witness statements to argue the accused knew abuse was occurring or should have recognized signs of danger. Defense attorneys often closely examine whether the injuries were accidental, the accused actually knew abuse was occurring, medical conclusions are reliable, and the prosecution can prove intent or knowledge beyond a reasonable doubt. A conviction can affect more than freedom. A conviction involving child abuse-related offenses may have life-changing consequences beyond incarceration itself. A felony conviction may affect child custody and visitation, employment opportunities, professional licensing, firearm rights, housing opportunities, and reputation within the community. Even before trial, these allegations can place enormous emotional and financial pressure on the accused and their family. Defenses may exist depending on the facts. Every case depends heavily on the specific facts and evidence involved. In some situations, defenses may involve lack of knowledge, false accusations, insufficient evidence, medical disputes regarding the child's injuries, lack of intent, and constitutional violations during the investigation. Because these cases are often complex and emotionally driven, early investigation and evidence preservation are extremely important. Creek County Criminal Defense Attorneys. Many people make the mistake of attempting to explain the situation to police or DHS investigators before speaking with an attorney. Statements made early in the investigation are often later used by prosecutors during criminal proceedings. Because these allegations can carry serious felony exposure and possible prison time, individuals facing accusations involving contributing to child abuse should seek experienced criminal defense representation as early as possible. Our criminal defense team at Creek County Attorneys is here to advocate for you. Call us at 918-209-3709 for a free and confidential consultation.